Continuing our discussion with County Prosecutor Mark Nichols. Mark, another question about with close that hits close to home, really, in the county level. This thing with comment with this litigation. I know you may not be able to make comment about it, about with Celinda, with the treasurer. Want to make comments about that, if you can?
Sure, and I note at the outset that I think the matter you're referring to is a public records suit that's been filed against the county and several of its officers, but it is not filed against the treasurer, to be clear. And so, as you may or may not know, our state has a sunshine law, so named because it's designed to shed light on documentations in the inner workings of government. The OPMA is one such law. The Public Records Act is another. And it's through the Public Records Act that citizens can request records from government to learn more about the goings-on within it. That's really good policy because the taxpayers who fund government should have a right to know what's going on within it. So this is a case where the county, on the one hand, the prosecutor's office on the other, the DCD department on the other, have been sued for an alleged violation of the state's Public Records Act. The matter is pending, but as evidenced by discussion in work session with the Board of Commissioners this morning, they, as the spokespersons for the county, the decision maker for the county, and as the county body that holds the keys to the purse, are considering the possibility of a settlement. And so, I don't know if you have specific questions, Peter. I can try to answer them. There's certain things I can't answer ethically because it's a matter of pending litigation, but I can identify who's involved in the suit. And talk a little bit more about the act, for example.
Well, there's this allegation that she's not being heard, or she's able to not express herself. The treasurer not able to express herself, free speech and so forth. Do you think any of that kind of stuff is happening? Do you think?
No,
can you comment?
My experience working with Celinda is that she's well capable of and does express herself. So I don't believe that there's any legitimacy to that at all. She was there today participating in the discussion publicly, so I think that's evidence of the fact that she does express herself, and I think she does that probably more actively than most of my elected clients.
Okay, now for the creme of the creme, the big question what brought me here today.
I'm dying to know.
One of the local publications made this allegation against the deputy mayor. You know that of committing perjury during an ethics board committee testimony, and he in the publication made the comment that nothing has been done and is like it's been dropped, or indication or implying that no word on it whatsoever. What's been going on? What's the status of it? Did the AG going to investigate, or has he dropped it, or so forth and so on? So if you have any comments regarding that, that'd be good.
Okay, and so you're talking about the perjury allegation made as to Deputy Mayor Kidd with the city of Port Angeles?
Yes.
Okay, so I can provide a bit of information. I know at the outset that my office is really not involved in that matter by design, but we are aware of, I think, the current status. And so, by way of brief background for your viewership, obviously there was an allegation brought forward that the deputy mayor had committed criminal perjury. That was initially made, that accusation, I believe, to the Port Angeles Police Department, who do an actual and or perceived comment, and I'll come back to both of those in a moment, I think made the wise decision to outsource investigation of the complaint. It wound up going to the Jefferson County Sheriff's Office, and there was a person there, I believe his rank might be detective, last name Gibo, or perhaps Gibo, and he was brought on board to investigate that allegation as someone who did not work for the city of Port Angeles government. Also a person who really didn't work with it. He's geographically removed and organizationally removed as well. And so, to the best of my knowledge, he investigated the allegation, and of course, prosecutors rely on law enforcement to serve as their eyes and their ears, and to bring us information upon which we can make an informed charging decision. I know that Mr. Gibo has been in contact with the Attorney General's Office Criminal Division, which is working on this matter. And the reason I know that is because I was at a elected prosecutors conference just last week, and the head of the criminal division of the state attorney general's office was there, and when she said hi in passing, she mentioned that her office and division was working on that referral. So there may be a perception that nothing is happening, but I think what's actually occurring is that a process is playing out behind the scenes. I full well expect that when the time comes, a representative from the state attorney general's office criminal division will issue a decision in regards to this matter. Now, the decision could take different forms. There could be, if you envision this along a spectrum, a decision to decline charges based upon lack of evidence or insurmountable proof problems. There could be a request to send this back for additional investigation to Mr. Gibo, or there could be criminal charges filed in the appropriate court. I have not received word from the Attorney General's office that they've reached a decision in this case yet, but I have every reason to believe that they're working on it.
Okay. Well, thank you very much, Mark, for allowing me to have an interview today with you.
You're welcome.
Any final comments before we wrap it up?
I think the only final comment I would offer, and this goes back to my mention a moment ago of the City of Port Angeles Police Department's decision to outsource the investigation of the complaint directed at Deputy Mayor Kidd. I made a statement to the effect that that decision was based on a concern over a perceived and or actual conflict of interest. The conflict of interest might have existed had the police department kept that matter in-house, because Deputy Kidd, a participating member of the council, is going to be involved in making certain votes, as it were, in relation to the setting of city priorities and budgetary matters. I think it's problematic for a police department to be investigating a decision maker in relation to its own budget. So that decision to outsource, I think, was sound and made for very good reason. Initially, the referral was directed to this office, and for a very similar set of reasons, I made the decision, exercising my prosecutorial discretion, to outsource the review of the referral to the Attorney General's office for a few different reasons. And these have not, to the best of my knowledge, been reported on, although I've been asked about them before. So, as I think you know, the county courthouse is located directly across the street from the city of Port Angeles. It is a sister government to the county. We work closely with the city on a number of fronts, and for that reason, it's important to have a positive rapport and relationship to the extent humanly possible. For prosecutors, we have different types of conflicts, I would submit, as with the department. In this case, I didn't perceive there to be an actual conflict of interest. In other words, in making a charging decision, I wasn't going to be personally benefited financially one way or the other. That would be a clear example of a conflict of interest. But from an optics perspective, that is, given how this might look to our community, and I'm very sensitive to it, and also based on the close relationship that the county has with the city, I made the decision to go ahead and direct the referral to the State Attorney General's office, which has statutory authority to assist county prosecutors in this regard. And that was done for a couple reasons. Number one, to cure the optics issue. to the theory that, you know, it might be a little too cozy to have a sister government's county prosecutor reviewing a referral as to an allegation of criminal perjury by an elected official in a sister government located right across the street. Some may agree with that. I recognize others may disagree, but it's a legitimate issue to consider, is what I'll say. Separate and distinct from that, and unbeknownst to the traveling public, is that criminal perjury is not a common allegation. In fact, I can't remember the last time that we received a criminal perjury referral to this office, and I've worked here for well over a decade. The Attorney General's office has an assistant AG on staff who's specifically versed in and well-trained in the prosecution of criminal perjury. So they're familiar with the statutes, they're familiar with applicable court case holdings at the trial, appellate, and Supreme Court level. And they know more than, frankly, anyone in this office about the nuanced way to go about reaching a charging decision and or on the alternative, declining to prosecute based upon legitimate criteria. I recognize the criticism can be made that by sending the referral out of the county, we've lost local control over it. But frankly, by sending it out, what we've done is we've maintained objectivity, which I think is critically important when you look at charging a crime. And that's the case because the act of charging is something that really can change a person's life. I've often been quoted as saying the power to prosecute is the power to forever change a person's life. And we want to make sure we get the decision right to the extent humanly possible. And I think our AG's office has a great track record of doing that.
All right. Thank you very much, Mark, for your
welcome.
time, and catch y'all and the readers and viewers. Catch y'all next time.